everyone, and welcome to InnoEnergy's Intellectual Property channel. We are the Intellectual Property team, and in this short webinar we will discuss some essential steps to develop an effective intellectual property strategy, and we will hereby also address the mistakes that are often made by startups that begin to work with intellectual property. So first of all, and most importantly, you need to make sure that your business actually owns your patented inventions. So in most instances, if you're an inventor, you will put your patented inventions under your name as assignee. However, if you have formed a company to develop and or exploit the invention, this might be a problem, as you will ordinarily transfer ownership of your invention to the business entity that you formed. So if you're the only owner of this company, such a transfer is not a problem since you own the entire corporation, so the invention will remain yours. However, if you're in a partnership or shared company ownership with more people, you'll be giving part of the ownership of your invention to the fellow business owners. So your partners will now be co-owners of an entity that owns your invention. Furthermore, problems might arise when the assignee is not the company but the inventor or boss, and people often find out too late about this, and this can, for example, become a problem when you want to license out an invention as the company. In this case, it might become unclear to the patent system who has the right to license out the patent, and moreover, inventors or employees to whom which the patent is assigned may leave the company. And this can lead to administrative hassles, problems, and even litigation. So please always make sure that the patent is assigned to the right name in the beginning. So second of all, if you're developing your IP strategy, you should take into consideration all the collaborations with outside partners. So questions you must ask yourself, for example, are will you have non-disclosure agreements with these companies during the negotiations? And how will you make sure that no sensitive information or important information is leaked? So furthermore, many startup companies will enter into license agreements with larger institutions at some point. And during these licensing negotiations, it is shown that not all startups have sufficient legal expertise. And as a result, startups often enter into unfavorable conditions to the startup in the long run. So for example, they will enter into licensing terms that call for excessive milestone payments or that do not allow the startup to unilaterally terminate the agreement. So a license agreement can also call for a non-compete, through which the startup will be limited into whom it can do business with. So startups should recognize that IP terms are important in early licensing agreements, and it's therefore recommended to obtain IP counsel from an expert so that they can review the terms of licensing before you sign. The third point is that you should consider that not all inventions are suitable for patent protection. For example, most biotechnical inventions, software, and business methods cannot be patented, and a startup should therefore also consider all other types of IP protection to protect all of their intellectual property assets. You can think about, for example, copyright to protect your software. But you must also remember the importance of your branding and associated trademark registrations. And furthermore, it might be smart to consider that the patent system requires you to publish the patent after 18 months after you file for the patent. And many large companies monitor patent publications to keep up with competition or to get new ideas. So if you have a very creative discovery or idea actually, A patent application will tell the world about it after 18 months. So it just makes sense in this situation to consider keeping your innovation a secret, especially in the case where you think that you will not get a patent grant, because it will still get published after 18 months unless you withdraw the patent application. So at last, and this is incredibly important to remember, is that with presenting information online, you might be robbing yourself of a patent. And this is because a patent cannot be obtained if an invention was previously known or used by other people in the world. So if you give away any information publicly concerning your invention, this will be regarded as information previously known by the public. And what is regarded as public is very strict. For example, if you present your product at a conference or workshop, this is already seen as being known to the public because they had access to it, or some people had access to it. Even one person would be considered public knowledge, unless there is some sort of non-disclosure agreement, of course. So in some countries, however, there is a grace period, and a grace period is a specific period of time preceding the filing of a patent application, during which certain types of public disclosure of the invention are considered to not be novelty destroying. So this mostly relates to publications by the inventors themselves. And in the US, there is a grace period of 12 months. So 12 months before the patent filing, disclosures by the inventors themselves might not be considered as novelty destroying, and you can still file for the patent. But usually this is not the case, and especially not for Europe. So we have now come to the end of this webinar. If you have any questions or would like to know more about intellectual property strategies, you can always contact us. We'll be more than happy to further advise you. So you can contact any of us through LinkedIn for questions. And thank you very much for your attention, and hopefully I will see you again at one of our other webinars at the InnoEnergy YouTube channel. Thank you very much.